Hi everyone, welcome. My name is Eva and I'm the Chief of Staff here at Margik. I'm happy to introduce Dr. Margaret Kocherga, who's Margik's founder and CEO. She discovered the company's product during her dissertation for a PhD in nanoscale science and founded the company in 2019. So if you have any questions throughout the talk, feel free to leave them in the chat or the Q&A section on Air Meet and I'll get to them.
All right, well, Eva, thank you for introduction. I will do a little brief what's going to happen today. Today is slightly different style of presentations. I will keep it more a little bit podcast style, where we're going to ask some questions, answer some questions. Not a whole lot of presentation. Going to be, as this is not intended as legal advice. This is strictly my personal experience with the topic, as well as me going through the journey myself. And there's ultimately a lot of variables depending on the industry that you're in, the university that you're in, the country that you're in. But I can just guide you through the process that I went through and what my experiences have been and what steps have I taken, and maybe it can help you also have some heads up on what you can be anticipating and things like that. So with that, let's start on with some questions.
Okay. My first question is, what type of IP exists?
So as far as intellectual property or IP, we'll be referring that just to save some words. There are several things you can do. There are things like obviously patents that you most likely heard of. There are things like trade secret, which is also a very common thing to do. Trademarks. There is service marks, copyright, and depending on the type of product or service you're offering, one or the other thing might be appropriate or a combination of them. So for things like Margik, name of the brand, and the logo, we are filing for trademark. But there are some rules about use cases, and you can only file it in a particular industry you're servicing. You can't just do it across the board. It has to be every time a separate application. Copyright is very typical for artwork. So I own personally a copyright for a ballet I choreographed, and I own copyright. But same thing with copyright, it has to be in use, otherwise you lose the rights to own the copyright. Trade secret, you probably have heard most commonly with things like foods, but it's also common in other industries where you don't want anybody else knowing what you're doing because there's something very special within your recipe or an approach that you're pursuing that you want to keep inside the company and you don't want anybody else to copy. And that one is very tough because you really cannot disclose any piece of that trade secret, and your internal processes have to be really well established in order to keep everything qualified as a true trade secret internally and not disclosed. And the patent is a way of protecting the ownership of your invention, but at the same time, it is fairly public, right? So your patents have a lot of details about your invention, and the patents, even though you own the rights for some period of time, at a 20-year mark, they are meant to be public knowledge. They're meant to be publicly disclosed information that anybody can access as sort of your legacy. So there is upside and downside to such setup, but in the technical hardware industry, it's very, very typical to have patent protection for your inventions as a way of structuring the commercial side of things, especially for international production and sales, and a way of regulating your competitors, maybe even to some level.
Okay. What were the first steps to decide to file a patent?
Yes, so as for those of you that aren't aware, for historical why our technology kind of came about and how it came about was I was a PhD student at the University of North Carolina at Charlotte. And I was working in Dr. Tom Schmidtke's lab, who is a very known silicon chemistry focused scientist. And as we were doing research, I was obsessed with organic electronic devices and really tried to find any way we could utilize the materials that we're making and how we can perfect them to be utilized in organic electronics industry, organic lighting, photovoltaics industry. And we weren't doing research for the sake of patenting, right? Which sometimes for a lot of companies, that's the case. You are building a patent portfolio, so you're looking for gaps in certain industries or things not covered by other patents, and you're seeking the content. This wasn't the case for us. We were doing research for the sake of addressing the problem in the scientific community and the gap in the scientific knowledge. And as I was pursuing customer discovery opportunities, commercialization opportunities, I realized that there is a gap on the commercial end of things, and that gap can be addressed with our research, and that there is a commercial value attached to what we're doing, not just the scientific knowledge that is often quite far removed from your end product seen by the customer in the commercial spectrum of things, right? So your academia is mostly the knowledge expansion, and a lot of the inventions are very in depth and not always become public products, versus your commercial level of research is typically targeted at the goal is to produce the end product to get it in the hands of customers. So that's where it stemmed. We have the combination that met together of academia, academic research, and commercial need. And that's what resulted in decision to file a patent, is having that need being met and trying to get the research outside of the academia into the commercial space. That's why the patent was filed.
Okay. What happened once you did the search and decided to file for the patent?
Yeah, so our situation was that we have already made a publication in a scientific journal, which by the rules of filing patents, if you made any public statement of your invention, you have a 12-month period to file a patent. So you have to be really careful about what statements you make and how you announce anything to the world, on both commercial and academic world, because you can self-expose pretty much, and you will kick yourself out of the opportunity you could have otherwise had. Now, that doesn't mean you should go out and file absolutely everything you're doing. There should be rhyme and reason to it, but you do have that 12-month period to do that extra research, to do that extra communication, and understand whether or not this is something worthy of pursuing. And the reason why I say it's not reasonable to do every single filing as a patent, because it is very long, very time consuming, very expensive thing to do, and has a high failure rate. Not everything is patentable. Not everything can be put into valid claims. And many patents fail for that reason, that it just doesn't have enough merit to it. Now, there is a little bit of a trick that you can play to win a little bit of time if you are uncertain if your invention is worthy of a full patent application, or you don't have enough merit to build your case. And it's called provisional patent application, but it's only available in the United States. Now, that doesn't mean that if you don't live in the United States, you cannot file for it. You absolutely can. In fact, many startups use this system. Internationally, they file a US provisional patent, which also secures another 12-month worth of time that you could be pursuing further discovery, do further research, whether your claims are valid. And it's a much shorter application. It's only a couple pages long. It's fairly inexpensive in comparison to, especially in comparison to patent. It's not that expensive. And it's very quick to put out. And what it does, it reserves that initial invention date, right? So if somebody else for some reason ends up coming up with similar idea to yours and claims that, hey, they copied my idea, well, your provisional patent will actually state the date of your original submission of your idea, even though you have that 12-month delay on the full application.
What happened after filing the U.S. provisional patent application?
So we did end up waiting out for that period of time. I don't think it was full 12 months, but it did give us some time to do further research into the claims and further build up our case to make it as valid as it can possibly be, as comprehensive as it can possibly be, and understand what would be the valid case from the scientific perspective, as well as commercial desire and need, internationally and locally. So after that, we filed what's called International Patent Cooperation Treaty application. And often you will see on the applications acronym PCT. So that's what PCT stands for. It is an international filing that allows you to then further pursue filings of the patent in other countries. Now, what we did was we did a US patent filing, Canadian, Japan, China, South Korea, and at this stage you also can file European Union, where all the countries that are in the European Union that are qualified under PCT, you can file at this stage. Now, it doesn't mean you will hold the rights to all European Union ultimately, but at that time, while you're still deciding, well, which European Union country is worthwhile for me to invest into and hold the rights in, where my customers are geographically located, this is a good approach to go ahead and just file the European Union one. It's not that much more expensive as a particular country at this particular stage, so it is worthwhile to just do the whole EU system and then decide on which particular country you want to pursue the full patent filing. So that is what happens at this stage. It is a lot more expensive stage of the process, as it does involve translating your claims to the language of that country. So at that point, you become more involved in the legal realm of things, and you have not only your filing fees and your lawyer fees, you also end up having your translation fees. Now, some people will tell you to use tips and tricks on cutting down those costs, but what it comes down to is not every law office will allow you to do translation outside of their office. And some may say, well, they're just being greedy. True, sometimes it's true, but a lot of times they want to be certain that the language is used appropriately, and it will save you from later on failures of translation, that some improper words were used or there were twisting of the concepts through translation. So some offices may allow outsider translation interpretation work, some do not. So you might want to check with the office that you are using. Now, we were restricted by the fact that I was a co-inventor when I was still a student on the patent, and the patent is fully filed by university. So we had a restriction on what lawyers we can use, because it had to be the lawyer that university can use. We got lucky and the lawyers were good. But I've heard some horror stories when it's not the case, and you do need to seek outside legal help. And that's not to be said that I hadn't shopped around and looked around whether or not what I'm being offered is being fair and is being addressed appropriately. So that's always, right, use your customer discretion to all those things, but that just heads up that you might be limited in your choices by the fact that you are at a certain institution, whether it's academic or a national lab.
You mentioned the countries that you filed. How did you choose those countries?
So, yes, for the countries, we ended up pursuing those that we knew historically had produced products that a product will be used in, or the same product we are producing similar to it. So that's what usually is recommended, is not exactly to have a patent where you're going to be producing the product, because it may not be the same country as where your customers would be purchasing the product. So you want to compare the two, where your customers purchasing as well as where your competitors are most likely to be. Sometimes it's the same country, sometimes it is not. So that's the comparison you want to go through, is where your customers at, where your competitors at.
What happens after the PCT has been filed? And again, for the audience, if you have any questions for Margaret, feel free to put them in the chat or the Q&A.
Yes, so for after the PCT, it is about a 30-month process, and it's a process, not just you submitted it and down you go. You just wait for somebody else to sign off. No, it's fairly involved. And because regulations do vary from country to country, for some countries we had to redesign some of our claims. Some of them we had to take away completely because they were not valid in those countries for one reason or another. Some of them we had to combine because of the rules and regulations and some of the additional charges that we could have been facing if we weren't doing those things. So that 30-month period is really, we can call it kind of negotiation part of what gets to stay in your patent, how much more proof you need to provide, what do you need to revise, what other appeals you might have to make. You might get declined at this stage at a particular country as well. And then you have to file for an appeal to, again, understand why it was declined, whether or not you can fix it. At this stage, I have seen other inventors travel to the country and have an in-person hearings. We have done only remote. We hadn't had the need to do an actual defense at an actual hearing. So hopefully we won't need to do that. And we can have some smooth sailing, but it is not atypical for things like that to happen, for you to have to go in and defend your case and why the claims that you're making are valid claims and not off the ceiling. You didn't just put something imagining in your patent. But the phases here, most likely you will see the name called national phase applications. And usually they're going parallel with the US national one. So one does not prevent the other. They are separate, but they can just go in parallel. So you'll have your internal PCT application as well as your national phase application kind of run simultaneously.
How much did it cost for you to file as a founder?
Yes, so as a co-inventor and a founder, I found myself in somewhat a funny situation where I'm a co-inventor, but I don't exactly own the patent. It's belonging to university, but I'm also a founder at a company that I own myself and licensing my own invention to myself. So it gets quite hazy quite quickly to go through all of those legal terminologies and whatnot. But overall estimate, so right now with one of the patents, we have gone through your preliminary application. We've gone through PCT filing, and right now we are at the national stage applications phase, quite far in advance of it. And we had to do some appeals, we had to do some restructuring for those applications. So right now we are pursuing 6 countries in our applications, and that is current total $22,000. And we're still anticipating probably another 10 to 15K worth of fees upcoming. And that is before the maintenance fees, right? So we're still talking about just the filing fee structure.
What do you anticipate happening upon the successful issue of the patent?
Yes, so if we are successful, we get the full rights to the patent, which would end up securing a protection for the next 20 years of the patent from the date of issuance. And what a lot of people don't think about is the fact that, well, I paid for filing, I'm good and done. It's all active for 20 years, life is great. No, that's not the case. There are filing fees. And those filing fees schedules differ, once again, depending on the countries, depending on several regulations, depending on how many claims you have, and the fee structure differs. I want to share very quickly the USPTO website, which does go through several of those things. So one of them is the PCT fees. So if you look up PCT fees in US dollars, it is fairly regularly is updated, and it does go through very detailed which stage costs what. Several countries are outlined, some of the common ones. So you can definitely find your rough estimate on the fees alone without your lawyer's fee. That will kind of give you a more clear answer on what their price is versus what the actual cost structure is. And then one more site I want to share also on their website is Patent Process Overview. It kind of guides you pretty nicely through. So if you do patent process overview, that's pretty straightforward. It really tells you at which step of the way where to find the information, as it might be quite hazy to try to navigate the website. And then one more resource that I found very useful was also USPTO fee schedule. This one, USPTO fee schedule, does go through after you have been issued. So there is filing fee, but there's also claims fee, as there is extra charge upon a certain amount of claims that you've made. There's some page restrictions you might be facing, utility fees, exemption fees, reissue, extensions. So that's all listed here, and the dates and the pricing and which schedule you would need to be using for that particular purpose. So there are all sorts of things that are listed here you can find very useful, especially if you're finding yourself struggling trying to figure out at which stage what you're supposed to be doing, and then figuring out how to get it all done. So yeah, there's that.
Okay, thanks for sharing those resources. You've touched a little bit on this, but as a founder, what's your experience been like licensing from a university?
Yes, so there are quite a few things I hadn't covered. I'm going to try to keep this as short as I can in the interest of time. Even before filing the patent, to me it was an interesting experience, because you have to defend to university to even file the patent, right? Because they're paying for it, they're investing their money, their R&D money into that patent. And I was actually able to defend my case myself. Even though I was a student, I was given a voice to defend why this invention has to come to life, that we do have commercial interest for this, that we do have market justification of why this is a valid invention and how it would benefit the greater community. So many of you will face that step as an inventor at a university. You have to defend to university why this is a valid idea to invest in. And to this day, any invention, any filing that's coming along, university pays that fee first. And then we as a company cover the fee later on the schedule, but they file all the filings and all the fees up front, and then we do that later. And as far as the structure of how you license the IP, usually you start with a material transfer agreement, which is a no-cost thing to do if you're just looking at a novel opportunity and it's not your invention. But even if it's your invention, for strictly R&D purposes, you can use material transfer agreement to be able to utilize the invention and see what that invention might do for you, how you can use the technology and make some progress on market discovery. The next stage then is to begin commercialization process of that product, but you're not allowed to pursue it without an option to license agreement. It is much shorter document. It's usually 6 months, can be extended, and also it is a requirement for things like applying for government contracts and grants. You have to have option to license agreement in place from the university about the patent that you're about to license, even if it's still in the filing stages, which that was our case. After that, you usually get a license term sheet. A license term sheet is a much shorter, condensed version of a license agreement, which outlines really the key factors of the agreement that are important, most important things to both parties. And because it's a much shorter agreement with much more important terms, you can significantly cut down the costs on the lawyers and the time spent negotiating over the little nitty details, which are often not very important. And then after that license term sheet is settled, you then go into the full license agreement, which will have a lot more elaborate terms included, and you'll spend a lot more time developing, because that will be most likely for the time of you having the opportunity to have that licensing agreement.
Interesting. Well, my last question for you is, what do you wish that you knew when you started this process that you know now?
Yes, is talk to people, talk to other university partners, talk to other founders, talk to investors, because each of these parties will have different preferences, different things that are important to them. Something that you might think is important may end up being very negligible factor, and in something that would have been important for, let's say, you getting the next investment, you didn't pay attention to, and now you're pretty much screwed, or you'd have to invest into a lot higher fees on the lawyers to try to renegotiate and restate the agreement all over again. Many universities are inexperienced in things like that, so it becomes very hard to negotiate some of the terms, as they are scared because they hadn't had the opportunity to see the whole system operate and work. So I wish I would have asked a lot of these questions much earlier on about the whole process and what to pay attention to, what to kind of let it slip. It's not as important because you can't renegotiate absolutely every single term of everything, but the key points and the most important things that do have a long-lasting impact is important to know up front. And sometimes it's very difficult to know whether your lawyer is offering a good solution or not, which is why I said you kind of have to shop around and find who's the right solution for you to advocate on your behalf.
Okay, very interesting. Well, I'm not seeing any questions come in through the chat or the Q&A, so I guess we're done. Thank you so much, Margaret, for coming today. And I'll be putting, for everybody in the audience, I'll be putting the recording up on our social media channels this afternoon, if there's anything you want to review.
Thank you, everybody, for your attention. And if you want to see any of our past webinars as well, go on our Margik YouTube channel, and you will see past webinars there as well. There's lots of great information, and we do these webinars every 2 weeks. Thank you. Bye-bye.